Well, good morning. Okay, Paul Rabelais here. Welcome back. Give you a quick intro. I'm Paul Rabelais. I'm an estate planning attorney. I happen to live and work in Louisiana, and I'm in my kind of dining room slash living room where if I look out these big windows that I have to the left, the outer bands, I suppose, Tropical Storm Cristobal are upon us. So rain is in and out, a little bit of wind. It's not a real powerful storm. I don't even think it's going to make it to hurricane status. Kind of, and where we are in Baton Rouge, Louisiana, when it hits that Gulf Coast, I think it's supposed to be maybe 50 or 60 mile an hour winds. When it gets to where we are, which means it probably has to travel maybe 60 or 70 miles over land, it will weaken. So we may get some 30 or 40 mile an hour winds. So anyway, that's what's going on. If you got a Cristobal story, feel free. Also, if you got a joke, feel free. My jokes are pretty weak, but I throw them out there. So I know you'll get a chuckle. You don't have to admit that you laughed when you read my joke, but I know you did. So feel free to check out the joke of the day. We're in YouTube live presentation number 2 of 20 daily unique YouTube live presentations. Going to do 20 of them. This is number 2 out of 20. So we'll be doing them for consecutive days, 10 a.m. Central Time every single day, all on a different topic. And you could go on our YouTube community page to see all of the upcoming topics. You can go on our website on a blog post. You can see all of the topics that are going to be presented over the next 18 days after today. So we got a lot going on. Thought I'd start it off, even though I know the title of this is Will or Living Trust, and we're going to get to all of that in detail. But I thought I'd saw a question or a comment, which turned out to be a question, pop up on a comment to one of my YouTube videos. I thought I'd just let you know what people are asking, let you know what my answer are. Is EJ, if you're listening in, great. If not, that's okay. Kind of, oh, by the way, we always have a few folks on these YouTube live presentations, but the beauty of doing this through YouTube live is that, yep, you can watch it live, and there's a few folks out there watching it live, but YouTube, with their website and with their platform, they record this presentation really automatically, and then it gets posted on my YouTube channel. So in case people miss the live presentation, then after YouTube processes the video, which takes a few hours, it'll forever be on my YouTube channel called Rabelais Estate Planning LLC, where you can discover everything and watch all these videos. Okay, but the beauty of watching it live is if there's questions, I'm gonna answer them. So feel free, if you have some questions, throw it in there in the live chat, and I'm going to see it, and I'm going to do my best to answer it. So watching live, you get your live questions answered. But nonetheless, got a question right here from EJ, kind of related to the topic of today. He says, my brother is executor in Michigan. He lives in the home that is to be sold to settle the estate and divide the money among beneficiaries. He is lying, saying he cannot move the house, isn't worth anything, and he states his name is on the house, but it is not. What do you do with a problem executor? Well, I'll give you a short answer, and I'll give you a long answer. What do you do with a problem executor? Well, if you can't resolve it amicably, then the next step is to get yourself a lawyer and attempt to have that executor removed from office. An executor has to do their job like any other reasonable person would do it. And if they fail to do their job like a reasonable person would, then other heirs, beneficiaries, other parties in the settlement of the estate have the right to ask that the executor be removed. And there would be a court hearing. Everybody would be put on notice, and a judge would decide whether what the executor did or didn't do was sufficient to remove the executor and then replace that executor with somebody else. So there's your answer. Yeah, and reading your question, it kind of sounds like that executor lives in the family home, and he's probably pretty comfortable in the family home. And so he's probably not in any hurry to transfer title of that family home to the heirs. And so maybe he just needs a little boost to do that. All right. So yeah, that is a bad situation. Thanks for your comments there, DKS. All right. So that's the best comment we've had so far. It's the only comment that we've had so far. So I'm going to acknowledge you. Good job, DKS. Okay, so enough on that. I think we laid the groundwork to go ahead and get started. Now I'm going to jump into this whole should you have a will or trust discussion. And when I sit down and talk to people, we got another question or comment. So I'll sometimes I'm going to just stop in my tracks because live questions are fantastic. Our house is titled JTWROS, which stands for Joint Tenants with Rights of Survivorship. I understand it goes to surviving spouse when first one dies. What happens when second spouse dies? Thanks for your videos. Great question, D.N. Preston Sr. So maybe there's a D.N. Preston Jr. who might have an interest in this house in the future. All right, so house, and in some states, not in my state, but in probably most states, couples who buy homes can title them in a way so that when one spouse dies, ownership automatically goes to the surviving spouse. That's what you did. It's common. It's easy. Joint tenants with rights of survivorship. So they're joint tenants means, they jointly own it, with rights of survivorship, meaning if one of the joint tenants dies, ownership automatically goes to the survivor. Okay. And then the question was, what happens when the second spouse dies? Well, typically what happens, it's now owned solely by that surviving spouse, and it's going to be part of that surviving spouse's probate when that surviving spouse dies. Kind of relevant to the topic at hand today. So we'll dig into whether now maybe that surviving spouse could title it in a way that it goes to the heirs when the surviving parent dies. I'm not an expert on joint tenants with rights of survivorship law, but if there's multiple children, that may not be an option, probably isn't. So we'll talk about maybe whether that surviving spouse, should put that house in a living trust to avoid the probate, or whether that surviving spouse is okay leaving that home in the name of the surviving spouse and allowing the court supervised probate process to transfer it to the heirs in the future. But excellent question, and something I think today's YouTube live presentation will help. All right, so a lot of people, when they come in, kind of the first words out of their mouth are, I just don't know whether I should have a will or trust. And really, I don't really like that when that's the first words out of their mouth, because that's not really what they're concerned about. There's a number of kind of underlying issues that I need to pull out of them before we start talking about what tool or vehicle is required or is appropriate to accomplish what they're trying to accomplish. So, when I dig it out of people and they tell me their kind of emotional reasons for having a conversation with me, then that stuff comes out of, I've been married twice and I don't want my new husband to fight with my children from my previous husband, or I have a child who has been in and out of, drug and alcohol issues. So I want to address that. So we got to kind of pull out those underlying issues and then determine, well, what vehicle, what tool is appropriate to best accomplish what you're trying to accomplish. All right. Thanks for tired and retired. I like that. So although if you're retired, you should now be rested. So maybe you were tired and now you're retired and now you're rested. Just guessing. All right. What is the role of a trustee? Does he have to issue tax forms like 1099 or any annual legal documents to beneficiaries? Great question. Maybe I'm going to put that off for a minute because we're going to get into the trust stuff here as part of this YouTube live presentation. But my and I think I'm glancing at your next question. Am I correct to understand that grantor or trustor files his or her? Yeah, so it kind of depends what kind of trust that trustee is the trustee over. And so quick one sentence answer, many people set up revocable living trust. They're the grantor, they're the settlor. Yes, they have children perhaps or heirs who are beneficiaries to receive the assets when the grantor dies. But under that kind of typical revocable living trust arrangement, the grantor has zero accounting, 1099, tax reporting, notice to beneficiaries. There's zero of that required. I'll get more into it in a minute. All right. So David, good question there. Is it wise or advisable to have an LLC be the owner of a trust? Would use of the LLC offer protection for the trust? I'm getting knee deep into these questions. They're all fantastic questions, and I was kind of mentally prepared to start with the very basics. But I love it when we get questions, so I'm going to do my best. Why have an LLC be the owner of a trust? Well, it's a tough one because there is no such thing as really an owner of a trust. A trust has trustees who manage the trust. The trust has income beneficiaries. The trust has principal beneficiaries. And an LLC could fill one or more of those roles. I would just say in general, it's not typical or customary, to have an LLC as the trustee or a beneficiary of a trust. And so if there is an LLC, then who owns the LLC? Some people ask me that question backwards than the way it was asked to me. Should a trust own an LLC? And then we'll get to that question in a minute when we talk about kind of typical assets that are owned by a trust. So good question, David. I don't know if that helped, but I'm going to come back to it in a minute. So keep your questions coming. Really awesome to see that. Also, there's a like button somewhere that kind of looks like that, and it's gray. It's real important that you make it blue by hitting it. So there you go. Yep, tells the YouTube algorithms to show my videos and maybe even your questions to more people. Okay. Hadn't even started yet, and I'm all getting excited and having fun and all that on a Sunday morning with a tropical storm bearing down on me. All right, so I did mention that the first thing that people ask me sometimes, Paul, should we have a will or a trust? And I'm like, we'll get to that, but first let's look at some of the underlying issues, which are, do you want to avoid the court stuff? Do you want to avoid nursing home problems? Do you want to make sure you name the right people to handle your estate? Do you have a surviving spouse that you want to provide for a certain way? Do you want to protect your children? Are there any of these underlying children issues with influential spouses, or they can't manage money, or blah, blah, blah? So we got to get at all those underlying issues. Who's going to make your medical decisions, your financial decisions in the future if you're incapacitated? So we got to get at all that. Then we get into the will or trust scenario. Nonetheless, the topic of this YouTube live presentation is, should we have a will or trust? So let's just jump into it anyway. And really, I'm going to look at this from 2 or 3 different angles. The first angle I'm going to look at it at is to give you an example of a married couple who is kind of normal. And then we're going to go through the will scenario for them, and then we're going to take a look at the trust scenario for them. So you'll be able to analyze in the context of examples and stories to start to get an understanding of what this will or trust conversation is all about. Again, another awesome question from Teresita. I am the fiance and the primary personal representative of the will of the person died. How long will the probate done? So I move to what I need to do. I think you're asking, how long will the probate last? Whew, man, that is a tough question. And looks like you had a fiance pass away. So first of all, I'm sorry for your loss. Second of all, how long that will take, oh boy, that just depends on so many factors that are unknown. And even if I knew what the factors were, I still probably couldn't accurately predict how long the probate will take. Some of those factors include, what state are you in? And there's some states that have mandatory delays built into the probate process because the probate process is designed to give creditors an opportunity to come collect their debts from the estate before anything gets transferred to the heirs. So what state you're in is a factor. How many people are involved in the probate, and what are the relationships of the people involved in the probate? It sounds like your fiance died, so I'm guessing maybe if your fiance had a will, maybe your fiance left things to you. Maybe did your fiance have children that were left things as well? Were there other heirs that are involved? All of those people are going to be participants in this probate. All of those people will have to sign off on legal documents from time to time. That sometimes causes delay because if you really want to get to know somebody, share an inheritance with them. So there's all those potential problems. And then, another factor is, do you have a really good feel for all of the underlying assets that your fiance owned? And so is there going to take some time to attempt to discover where he had bank accounts, where he had maybe some investments, if that even exists? So all of that is part of the getting the probate done. And so sometimes it takes, months, sometimes it takes years, all depending upon lots of unknown factors. That's a good question, and that's my best answer that I could give you based on the just limited information that you provided. Okay, so I'm going to give you an example here. Let's call them Bill and Jane. And let's Bill and Jane are quite the traditional couple. Let's call them old-fashioned Bill and Jane. They've each only been married once. They have 3 children, and all 3 children are normal, whatever that means. There's no, all these kind of drug problems, alcohol problems, none spendthrift problems, none of this. Bill and Jane, all they want is that they want to keep it in the family. They want, when one of them dies, they want everything to be for the survivor of them. And then they want, after both Bill and Jane pass away, just divide it up 3 ways equally, let the kids go their own way. So that is a pretty simple scenario. Before we get into the will or trust decision, let's go over what Bill and Jane own. And I'm going to give you what's typical. Bill and Jane own a home. And Bill and Jane may have 1 or more IRAs. Bill and Jane may have an investment account that's outside of their retirement accounts. Bill and Jane are going to have 1 or more bank accounts. Bill and Jane are going to have probably a couple of vehicles. And let's just say for fun, Bill and Jane also owned another piece of property. Maybe it was vacation property, maybe it was rental property, but they had that other piece of property. And also for fun, let's just say they owned a business. Let's say they owned an LLC, they had a small business, and so they had that as well. And so what they want is they stay in control of everything. One of them dies, all of the survivor dies to the 3 kids equally. Boom, end of story. All right, so option 1 is going to be, what if they provide for those dispositions in their wills? Option 2, what if they provide for those dispositions through a trust? What's the difference? All right, so here's the difference. So let's look at the will scenario first. Bill and Jane each have wills. Maybe I wrote them, maybe I didn't. Doesn't matter. But in general, Bill's will, for example, says, when I die, I leave everything I own to Jane, my wife. And Bill's will also says, if Jane predeceases me, if she dies before me, then I want everything I have to go to my kids when I die. And Jane's will says the same thing. Jane says, I leave everything to Bill. However, if Bill dies before me, then when I die, everything goes to our 3 kids. So they get those wills done. They feel good about it. Of course, they leave all of those assets that they own in their name. And then let's say 5 years later, could be 5 days later, could be 20 years later, Bill dies. That will's going to stay in effect until Bill changes it. He never changes it. He dies. What happens? Well, here's where it gets, here's where you need to kind of pay attention, because Bill and Jane owned some things that are likely to be frozen when Bill died, and Bill and Jane will likely own some things that won't be frozen. So let me get some things out of the way now, and just so we can get to the meat. So looking at our list of assets, let's say Bill had an IRA named Jane as the 100% primary beneficiary. Jane gets a death certificate. She brings that death certificate to the financial institution where Bill's IRA is held. And then the financial institution will move Bill's IRA into Jane's IRA. No courts, no lawyers involved in the transfer of Bill's IRA when he died, because Bill named Jane as his designated beneficiary. Most people understand that. Bill and Jane may have had a joint checking account. And when Bill died, let's say the bank, policy was that on the bank checking account, those joint accounts were not frozen when Bill died. Jane still had access to all of that. So that's good. But it's a different story for the home, the other property that Bill had, unless perhaps you're like D.N. Preston Sr., whose home is titled joint tenants with rights of survivorship. I'll come back to that. But in our state, they don't permit that. So that home, that other property, if Bill dies, if Jane, for example, if she wants to sell the family home and downsize, move closer to grandchildren, whatever, she can't initially sell that property because it is in the name of Bill and Jane. And to sell it, you need Bill and Jane, both of their signatures. Bill's dead. And so now the title is not clear. So Jane, as the executor of Bill's will, Bill named Jane as the executor. Jane will hire a lawyer like myself in whatever state Bill lived in. And my job will be to get lots of information on what Bill and Jane owned, prepare lots of court pleadings, get signatures from heirs on those court pleadings. After getting all of the information, detailed information on the estate assets, making the appropriate inventories of assets and debts and other things. And then paperwork gets filed at the appropriate courthouse. And then the courthouse employees kind of take over from there, where it gets submitted to a judge at some point. And if the judge and the judge's office approves all of the paperwork, meaning that if they determine that all of the procedural rules have been followed and everything is accurately and properly done, then the judge signs the appropriate court orders ordering that Bill and Jane's house, other property, vehicles, investments, all those assets are listed out. A judge will sign an order ordering that Bill's ownership interest in those assets be transferred to Jane. So then Jane gets copies of that court order, or certified copies of that court order, perhaps from the clerk of court. At least that's the way we do it here in Louisiana. And she brings those court orders or she gets them recorded in the real estate records of the parish or county. That makes Jane the new owner of the home. She brings that court order to the financial institution where Bill and Jane may have had joint investment accounts, or maybe Bill had an investment account in his name solely. The financial institutions would transfer ownership of those accounts to Jane. And again, remember, Jane already transferred the IRA pursuant to Bill's beneficiary designation. And then Jane may take that court order to the Office or Department of Motor Vehicles, where they're ordered to retitle any vehicles that are in Bill's name, put them into Jane's name. If they owned a business, then this order would require that whoever keeps the business records of that business retitle Bill's ownership interest in that LLC or that corporation or that partnership from Bill or Bill and Jane's name into Jane's name only. And if they owned other property, maybe they owned property out of state. Maybe they had a vacation piece of property in another state. Then this probate that Jane went through when Bill died doesn't govern the transfer of out-of-state real estate. So now Jane's got to go hire another set of lawyers in that other state where that out-of-state property is located and do what's called an ancillary probate in that state to get Bill's ownership interest in the out-of-state property transferred into Jane's name. So, and so that is how Bill's estate would be handled with a will, given that he had those assets and the will left everything to Jane. Now, once that's complete, Jane now owns all of these assets in her name, and maybe she sells the family home and, buys another one near her grandchildren or downsizes or whatever it is that Jane wants to do. She still has all these assets in her name. She dies later. Might be months, might be years, might be decades later. Now the kids. In Jane's will probably said something like, I leave everything I own to Bill. But if Bill predeceases me, I leave it to my kids. And every will names an executor. Maybe she named one of her children. Let's call Jane's daughter Linda. Maybe Jane's will said, if my husband Bill dies before me, I leave everything to my 3 kids, and I name my daughter Linda as the executor. So when Jane dies, everything Jane owns is frozen. And this gets into the kind of the question about when the surviving spouse dies, when the couple had previously owned the property, joint tenants with rights of survivorship. Sometimes I get talking really fast because I've explained this stuff over and over and over again. I want to get to the next point, but nonetheless. So when Jane dies, Linda and her 2 siblings, the children of Jane, come back, call my office, Mr. Rabelais, I went to the bank, I went to the brokerage firm. They said my mother's accounts are frozen. They said I need to do a probate. Can you help me? So then we start that process all over again for Linda, the executor, and her 2 siblings, the children of Bill and Jane. And so similar process, even a little bit more complicated, because now that the surviving spouse dies, it's likely that assets are going to need to be sold so that they can be divided up among the 3 children. So Linda comes to me, we file a bunch of court pleadings, we get Linda what's called confirmed as the executor, which is a bunch of court pleadings filed at the courthouse where we submit the will to a judge. A judge has to declare that it's a valid will. A judge signs court orders confirming that Linda is the executor. Once he does that, Linda gets court documents called letters of independent executorship, which she takes to the financial institutions to open up a new estate account. And then the financial institutions are ordered to move the money from Jane's frozen accounts into the new estate of Jane accounts, over which Linda is the executor of. And then Linda may need to sell Jane's home. She may need to sell Jane's vehicle. She may need to sell Jane's out-of-state property, all of which she may do. And the proceeds of those sales would go into this court-supervised estate account set up at the bank where Linda has the signature authority over the account because she's the executor. And then Linda comes back to me. More court documents are prepared, more inventories, assets, documentation to be signed by all of the heirs after they agree to our kind of proposed disposition of everything and how everything's been handled. We get all that filed at the courthouse, and then a judge signs the appropriate court order ordering that any remaining estate assets after costs have been paid be transferred to Bill and Jane's 3 children. So the estate account then gets dispersed out to the 3 kids and they go their own way. Okay. So that's the will scenario, which by all admissions is call it the traditional way that couples or individuals have left their estate. It's the kind of customary way. It's the way taught in law schools predominantly. So it's kind of in the movies. You always hear people say, got to get the will done. Or in the movie, so-and-so died and their will said this. Or so-and-so died and the heirs went to the stuffy law firm for the reading of the will, which rarely happens, by the way. And so most people just in general, when they talk about how you leave your stuff, they're talking about will. Oh, I got to get a will done. I don't have a will. So you hear a lot, will. So that's option number one. Then there's option number two, which is the other component of our presentation today, a trust. And there's a lot of different kinds of trusts out there. There's Christina, you are incredible. For purposes of our discussion today, we're really talking about what I'm going to call the most common form of trust, call it the revocable living trust. And by the way, my favorite real estate fellow YouTuber colleague is Christina Smallhorn. I think about 20 or 25% of the people who watch these YouTube live presentations live in Louisiana. If you're anywhere around the Prairieville area, you're going to check out Christina's YouTube presentations and, quite frankly, use her to buy or sell your home. Enough said there. Okay, so with that being said, let's look at the trust route. The alternative, because what you just heard was somebody dying and lawyers and courts being involved. And some people, they kind of cringe when they hear that. They don't like that. So the other way for Bill and Jane to set all of this up, and again, I'll give you the punchline ahead of time, it's done with the intent of eliminating the court and attorney involvement when they die. Because things that were in Bill and Jane's name when they died, they become frozen, and you have to get courts involved to order the transfer to different people. So the idea behind a trust, you could call it a living trust. You could call it a revocable living trust. I've heard people call it a living revocable trust. It all really means the same thing. It's Bill and Jane establishing a trust. And inside the trust terms, it says what happens when one of them dies, what happens when the survivor dies, and it's likely going to say when one spouse dies, everything stays under the control of the surviving spouse for the surviving spouse to be able to do whatever they want to with it. And then it's going to say when the surviving spouse dies, then daughter Linda is the trustee of the trust, where she was the executor under the will program. She's the successor trustee of the trust. And the three children are the beneficiaries of the trust. So will, you have executor, trustee, trust, you have trustee, will, you have heirs, or sometimes they're called legatees, trust, you have beneficiaries. And then another component of the Living Trust program is retitling Bill and Jane's assets to the trust. So this is a key component because when Bill and Jane bought their house, they bought it in their name. It's in the name of Bill and Jane. But to eliminate all that court and attorney involvement when they die, they've got to create a trust, and they need to retitle assets of theirs into their trust. So once their trust is formed and once they retitle their property, it's titled Bill and Jane as trustees of the Bill and Jane Trust, something like that. And so things that are titled in the name of a trust when you die, they don't have to go through the court system. They're not frozen. The government doesn't want or need to be involved in the transfer or disposition of trust assets. They are only required to be involved in the transfer or disposition of assets that are in your name when you pass away. So under the trust scenario, Christina, I thought you had more influence than that. So Christina, my parents need a trust. I keep telling them, but they won't listen. So maybe you could call them and tell them to get on this video right now. And you could even send them the link, or do what a lady did the other day. She said she bought my book and she wanted to learn more. So on Amazon, I have a book, and by gosh, I just whatever, Christina, but hey, at least maybe you've got a lawyer on your side in the event you need that in the future. Okay, so going through that, Bill and Jane have their trust. Bill died. what happens? Well, all of those assets that are titled in the name of Bill and Jane's trust, their home, their investment account. Yes, Bill's IRA, it has to stay in his name. You can't put an IRA in a trust while Bill's alive. But an IRA is one of those non-probate assets anyway. It goes directly to Jane because Bill designated Jane as the beneficiary. So no problems there. But as to the other investments, the house, the other real estate, all the trust says when one spouse dies, the surviving spouse is the trustee. They can do whatever they want to with it. So when Bill dies with all of those things titled in the name of the trust, Jane, she doesn't have to do anything. She doesn't have to call or go visit a lawyer. Nothing's going to be frozen. She'll continue to have access if she wants or needs to sell their family home to go move across town or across the country. She can do it immediately without having to wait on judges to order the transfer of the home, which seems to frustrate some people when they have to wait on the judicial system to even sell their home. All right, so the idea, Bill died, Jane doesn't have to do anything. She just keeps on going as the trustee of their trust, and then she sells the home. Maybe she sells investments, reinvests them. She just stays in control of everything. She may sell their home. She may buy a new home, and when she does, she'll buy it in the name of her trust, and that might be in the same state. It might be in a different state, and then years later, Jane dies. All right. And thank you for the comments. We got some really generous people out there. And Carolina from California, sounds like that ought to be a song. You've watched most of my videos and learned so much. Great to hear it. But now when Jane passed away, in Bill and Jane's trust, they designated their daughter Linda as the successor trustee, and they designated the 3 children would be equal beneficiaries when Bill and Jane died. So the day after Jane dies, let's say it's appropriate for Linda or the children to sell Jane's home or sell Jane's out-of-state property. The next day, Linda has that ability to do it. She doesn't have to wait on courts and lawyers to get involved and go through the court system to get things transferred, things in a trust. They don't have to go through that. So the day after Jane dies, Linda can, plop a for sale sign in the yard. She probably called Christina to list it for her. And Jane can go, or Linda, the daughter, can, as the trustee, can go to the brokerage firm where Bill and Jane may have had some investments, and the investment firm can set up 3 new accounts, one for each of the 3 children, and Linda can direct that the financial institutions firm move the funds out of the trust account into the 3 new accounts, one for each of the 3 children in equal amounts. And that's done literally within a matter of days after Bill and Jane pass away, instead of this traditional months or years that it takes when you go through the kind of court system to get things done. Okay, so most people, when they hear that story, they tell me, the trust sounds so much better, but I don't want to just slam this trust concept down your throat. I'm gonna dig in and reveal a lot of the follow-up questions, or what are the pros and cons? What are the disadvantages? I want to dig into some of that, where we dig really deep into this kind of will or trust arrangement. So let me tell you what some people say, and there's a lot of people who make an informed and educated decision to not have a trust and to use the will process to let that take its course. And then there's obviously many who use the trust route. So here's, after hearing the stories, here's what I hear some people say. So some people will say, well, Paul, when my father died, I don't remember it. He had a will, and I don't remember it being that difficult. And you know what? Not every probate has to be difficult. And, I might ask, well, when did your father die? And he might say, he died 15 years ago. He might say he died a year ago. He might say he died 30 years ago. And, often maybe the father just had a home, and so the assets were minimal. And again, because I just told you not every probate has to be difficult, maybe there was no big deal that it took maybe 3 months, maybe 2 months, maybe 6 months to get that home transferred. There was just no real rush to sell or access anything. So the people who say, you know what, I think I'm going to have a will because my dad had a will, and when he died, I don't remember it being difficult. Let's go with a will. And that's fine. That's an educated and informed decision. So some people, kind of go that route. Here's another thing that I hear people or lawyers say. Well, we have this new independent administration, so I'm going to use the will and name my executor to be an independent executor. Some people mistakenly believe that if you name your executor as an independent executor, there's no court involvement. So let me go over what this independent stuff is. Many years ago in Louisiana, before 2001, we didn't have what's called independent administration. And so somebody died with a will, they named an executor, and everything the executor did, from not only selling a house, but paying a light bill or paying a credit card bill of the deceased, every single action that an executor took, we'd have to go get a judge to approve it. We'd have to file these petitions to approve the paying of a bill. It was just a nightmare. And it was very expensive, very time consuming. Well, in 2001, at least in my state, the legislature authorized what's called independent administration. Now, there's still a probate when someone has a will and names an independent executor. It's just the executor still has to get confirmed by a court and all of that stuff. But now there's many actions that an executor can take independent of court approval. So if that independent executor needs to pay a utilities or water bill on the home of the deceased, they don't have to get the payment of that bill approved by a judge before they do it. But there's still a court process. Still, all of the heirs have to be represented by lawyers. It is more streamlined, but there's still the court process and still a lot of the inherent delay and cost. Okay, so that's the independent administration. Some people say, I really don't feel like a trust is for me because my estate isn't large enough. Or sometimes people will ask me, how much does one need to have to make a trust worthwhile? And it really isn't appropriate to ask the how much question. In fact, if somebody has a $200,000 home and they have $75,000 in frozen bank accounts when they die, and that's their estate, $275,000, they're going to pay a larger percentage of their estate in probate to the person who has maybe $2 or $3 million, because there's just thousands of dollars of costs that are involved in every probate. So it's not like the probate costs are significantly minimal when the estate is small. Now, we do have what's called a small succession affidavit, and if somebody dies, they have less than $150,000 of gross assets, and they have no will, and then the heirs can do this affidavit procedure. And we use that sometimes when it's appropriate, and that's easier than going through the full-blown probate. But it's not really the will or trust decision is not really a how much question. It's more of, do I want to keep things simple for me and just leave everything in my name? Sure, my heirs will have to go through some stuff when I die, but that's really not my problem. Or do you want to take that, I want to do what I can now to simplify their lives later? That's kind of the will or trust decision. Hence, my next kind of comment that I hear sometimes is, I don't really care what happens when I die. I'll be dead. And so, especially for those who don't have children and they may be leaving things to other distant relatives and to maybe even to charities, maybe for them that will program is appropriate. Leave what you have in your name. Yes, there'll be a probate when you die, and you've named an executor, and you've named charities and other relatives to get your stuff. And so I could see someone making an educated and informed decision to just go the will route through there. And then some people say, well, I don't want to put my vehicles and my checking account and my trust. And depending upon what state you are, there are many states, including ours, where vehicles and checking accounts can stay in your name, but still that probate process is avoided when you die, at least as to those assets. Just to give an example, many banks here in Louisiana authorize these payable on death accounts. the kind of informal way that a lot of people do it, because it quite frankly works, is, maybe mom will put daughter Linda as a signature authority on mom's checking account, so mom can keep her checking account in her name. When mom dies, Linda can access the account. It's not frozen. Linda can pay for the funeral. And so that's both a state issue and a bank by bank issue that would need to be addressed. So, but I will say, most people who make informed decisions, I'd say the majority tend to go the trust route. I will say there's some financial issues. Setting up a trust-based program is typically more expensive, maybe by a couple of $1,000s or so or more, is more expensive than setting up a will-based program, because not only with the trust program do you have to, set up all of the trusts and all of that, but you've got to retitle and what's called fund the trust. And I'm going to do a daily YouTube live presentation on funding the trust. I've done some other videos on funding a trust and what that means. So typically, though, there is more cost, and what that cost would be can vary based on circumstances and lawyer and state. So don't hold me to that. But the way most people easily justify, setting up a trust is that savings of time and effort and money and hassle on the back end, particularly when you have a married couple setting up their trust, and they're looking at eliminating the need for both of those probates or successions when each spouse passes away. So hope that gave you some insight. First objective should be understand your underlying objectives of what you're trying to accomplish first, regardless of the vehicle that you used. And then once your kind of what you want to accomplish gets uncovered, then it can be determined what's the appropriate vehicle. We've had a lot of people tell me, Paul, I did a will 15 years ago and nobody ever told me that a trust was even possible. And so, or why didn't they tell me? Just, I think it's because there's some lawyers who are just kind of comfortable doing the wills and then doing the probate when they die. I don't know. I can't speak for everybody else, but at least if you're watching this, that you have an alternative. And now maybe with the help of this video, you can start to make a little bit more of an informed decision about the best way to structure what you have for yourself, for your spouse, if you're married, for your children, if you have children, or for your other heirs. Okay, so that's going to wrap up the will or trust part. Tomorrow is a big one, totally shifting gears here. Tomorrow is all about another really popular estate planning topic of protecting the home, the life savings in the event that someone needs long-term care in the future, or nursing home. Those are very, very expensive. You've got to spend everything you've got. Most people who come into my office tell me that they know of someone, either a parent, a grandparent, or an aunt or uncle or a friend of a family, who did have to go into the nursing home and did have to spend their life savings, and they lost everything. So most people are familiar with the concept, and we're going to talk about a number of the planning strategies that you have to keep that from happening. One of my final comments, if not the final comment, is especially for those of you who have the Louisiana ties. In these days, I haven't met with a new client, and usually I kind of before all the COVID stuff, maybe once a day, I was meeting in the office with someone who had a legal need, and we'd talk through all of these things and come up with a program that accomplished all of their objectives. Haven't met with a new client since early March. Now, I've been busy, and because the way people are doing estate planning legal business today is they're going onto my website, they're clicking on that link or that block that takes you directly to my calendar to schedule a free 15-minute call, where I'll call you exactly at the time scheduled, and we'll start a conversation that way. And really, our clients have I've been shocked at how easy it is for them, and how much they've kind of insisted that they not come into the office, that we resolve all of these issues over the phone. Now, we're having a lot of people with our social distancing come into the office, get things signed. We get them in, we get them out. But so they're coming in to sign because there's all these formalities that have to be met and validities with notary and signatures and other things that we have to get together physically for that. But feel free to use that button on our website, rabelaestateplanning.com. Go to my calendar, schedule a time, describe the issue as clearly as you can, or at least in general what you want to make sure we talk about, so I can kind of be prepared for that. I'll call you at the predetermined time and we'll go from there. Okay, so I hope that helps everybody. Make sure you give it the thumbs up. Turn that gray thumbs up to a blue, and then also click the subscribe button and hit the notification bell. That way you won't miss anything. We'll see you tomorrow. Y'all have a great Sunday.